Good morning, all. My name is Adil Patel. I'm from Cliftaker Hofmeyer, and with me, a host of my colleagues, Imran Mohammed, Hugo Pinar, and Betin Kuna. I am literally going to chat for 2 minutes before handing over to Betini. The Employment Equity Amendment Act has been signed but is not yet law. Despite that, we have draft regulations that have been published for public comment. And this is yet another set of the draft regulations. To our clients and colleagues, we as a firm are in the process of developing a compliance tool to assist you to ensure compliance with these targets when they become law, as opposed to if they become law. But what is the purpose of these discussions? And as Betini, Imran, and Hugo will inform you, is to simply encourage that this is one set of legislation that you must comment on. We have seen the power of public participation in this. Imran and Hugo will take you through that, facilitated by Betini. They will illustrate to you how our initial comments by the public and clients that we've assisted with have shaped these draft regulations. So the purpose of today's discussion is not to provide you with answers, but to provide you with the challenges that we face with these regulations and encourage you, your organization, and the industries that you belong to participate in the public commentary. You have 90 days, because once it's passed, it is only the courts that will be the final adjudicators of it. So every avenue available to us must be utilized. And this is some cheap marketing. We are available to assist you to make those submissions. 1, 2, once these are published, there'll be a compliance tool to assist you to ensure compliance. But as always, look out next week for our second piece of the thought leadership guideline that will be released, which will highlight some of the issues which Imran, Hugo, and Betini will be dealing with. Thank you, welcome, and thank you for giving up at least 45 minutes of your Friday morning. I now hand over to my colleague, Betini. Thank you.
Thank you for the word of welcome, Adil, and a very good morning to our guests. I will kick us off with a bit of introduction and contextualizing what the sector targets are, at least from a timeline perspective, so that going into this discussion, we have a grasp of where we have been, what government is essentially seeking to achieve, well, from what we could read from the Amendment Act flowing into the draft regulations, and also look at where the 1st of February revised draft regulations leave us, at least for now. To our clients, if you have any questions, you are welcome to post them in the chat, and time permitting, we will deal with them. If you prefer a more direct approach or discussion regarding your business, what you should be doing, and how to respond to the minister's call for comments, please feel free to contact us on the webinar, on the details that we shared on the invite. We will also circulate contact details by the end of our session. On the 14th of April last year, the President signed into law the Employment Equity Amendment Act, amending various provisions of the Employment Equity Act. As Adil mentioned earlier, we do not have an effective date as yet. We are trusting that it will be proclaimed soon enough. As you would all know, the primary purpose of the Employment Equity Act is essentially to promote the right to equality and to ensure that all employees receive equal opportunities and are treated fairly by their employers. A core focus of the Employment Equity Act is really the implementation of employment equity and affirmative action to redress the effects of historical discrimination. In today's discussion, we will be confining ourselves to the new Section 15, capital letter A, under the broad umbrella topic of affirmative action, which is one of the key provisions that apply to designated employers. On that note, from the effective date of the Amendment Act, we will have a modified definition of designated employer. The Amendment Act has deleted paragraph B of the current definition, which provided that a designated employer is a person who employs fewer than 50 employees, but has a total annual turnover that is equal to or above the applicable annual turnover of small businesses as set out in Schedule 4 of the Employment Equity Act. So essentially, from the effective date, what will become the definition of a designated employer is, firstly, a person who employs 50 or more employees, large employers, essentially. Then secondly, municipalities, and then organs of state with the exclusions that are already stipulated in the Act. These are local spheres of government, the National Defence Force, the National Intelligence Agency, as well as the Secret Service. And finally, employers that are bound by collective agreements, appointing them as designated employers. Now, on to the specifics of Section 15, capital letter A. It has essentially granted the minister authority to firstly identify national economic sectors, as well as set numerical targets for these sectors. The minister may set different numerical targets for different occupational levels, subsectors, or regions within a sector, or on the basis of any other relevant factor. Section 15, capital letter A, has also implored or obliged the minister to open up for public comment regulations related to the setting of numerical targets. Initially, in the 2023 regulations, interested parties were allowed 30 days to comment. With the 1st of February draft, interested and affected parties have been given 90 days to comment. The purpose really of Section 15, capital letter A, is to ensure equitable representation of people from designated groups at all occupational levels in the workforce. I will quote what the Director for Employment Equity in the Department of Employment and Labor said in 2023. Self-regulation has not worked. Employment equity does not blindly promote racial discrimination. It promotes the advancement of suitably qualified candidates. As I mentioned earlier, in 2023, we had draft regulations in which the minister published draft 5-year sectoral numerical targets for the identified national economic sectors. Then we had a revised version a few weeks ago in which the minister republished the draft 5-year targets for the identified economic sectors, allowing interested parties to bring forward comments within 90 days. Why a second version, you may ask? The May 2023 version essentially generated quite substantial input from stakeholder engagements. The current version, from what we have read, seems to offer more insights in the process that government has followed in determining targets, as well as what it took into account. It also provides guidance on how to interpret and apply the regulations, or what will then become the regulations once the process is finalized. It also incorporates feedback, which my colleagues Hugo and Imran will later take you through, as well as address concerns that were raised during the previous round of public commentary. With that background, I want us to get into what has stayed in version 2, the 2024 version of the public regulations. Imran, if I can ask you to come in there.
Yes, morning, and thank you, Picheni. Well, there's probably five elements that have essentially remained the same. The first and the one important bit is that the 18 is in 18. I wish I could say 80 as in 80. Economic sectors have remained the same. So our economy hasn't grown to 80 sectors. Hopefully we'll get there. But the good news is that from 2023 to 2024, we haven't gone down from 18 sectors to 5 sectors. So that's good. So 18 sectors remain important or remain intact. What employers obviously need to do and have done over the last period is determine what sectors they fit into. The second aspect that remains the same is that the national targets set in the 2023 regulations have essentially stayed the same. So the sectoral targets have kind of mapped what they were in 2023, except for the finance and insurance sector, which is quite interesting, how that one moved, i.e. the one sector, but the remaining sectors all remained in place. The analysis over a 5-year target remains the same. And the numerical targets focus on, and it was exactly the same in the 23 regulations, on top and senior management, professionally qualified, skilled, and people with disabilities. And I just want to flag people with disabilities, because I think in all of the discussion around affirmative action, a fair bit of emphasis in relation to persons with disabilities gets lost. So we rightly focus on race and gender, but we kind of never really get into the discussion of people with disabilities, and that's something that I think we need to start looking at into the future as well. I mean, HR practitioners know it well. It's something that's always reported on, and it's an important element of affirmative action as well. And then the last point is that employers are required to set numerical targets in goals for semi-skilled and unskilled occupational levels on their own, so there's no sectoral target for that. So those essentially are the broad topics that have remained the same.
Thank you for those insights, Imran. Hugo, if I can just rope you into the conversation to just give us a discourse on what are the significant changes that employers all around South Africa need to be alive to with these revised regulations.
Prof,
Hugo,
you're
on mute.
You're on mute.
Good, thank you. Morning. Tini, I think the starting point is the good news, is that the Minister has considered and accepted most of the inputs that we've made, certainly as a firm on behalf of clients in the new regulation, and will hopefully continue to do so. When I say the Minister, I refer to the Minister of Employment and Labour. I know in some circles they refer to me as the Minister of Unemployment, but we don't have to go there today. But the important point is that we now have 90 days to respond, and parties should do so. And by commenting doesn't mean that you're criticizing and not embracing the principles of affirmative action. But of course, we know that, as we've seen in Malaysia and other countries, economic freedom political freedom does not meet economic freedom. So when we consider what is really new and what is helpful, certainly, is there's now a simplified reading, and I'm sure most of you have read these new regulations subject to load shedding, but most of you have done that, and you would have seen there's a simplified version. There's a detailed explanatory notes, so the implementation is much easier than what we've seen before. What is significant, though, is that that they've done away with the distinction on racial grounds within this regulation. draft regulation. But of course, what is important is that that does not mean that you should not take into consideration the economic active people, and that should be reflected at all levels and categories. They've also introduced the concept of you must choose either provincial or national stats, and of course, targets when you set. And of course, that brings about a possible constitutional challenge to what extent you should do so, and more so because of the provisions of the Act, which states provincial and national. So one will have to see how that will play out. And it's important that when you look at the new draft regulations, you simply have to look at the schedules and how complicated it was before as opposed to the new one. It's quite simplified. It doesn't draw the distinction and bring you into the provincial ones. It doesn't put in the different racial segments. So that makes it easier to read. And we know that the numbers won't always add up when you do the stats. And we've seen that in the previous submissions that we've made. There was much debate that it didn't add up, but of course it shouldn't. And it's the same thing here. And we will continue to do that. What is interesting that there is recognition again of the BBBE codes and targets and charters, so that is significant. What is also significant is that in the different sectors that they look at skilled strategies, market forces, and ownership. So I'm going to repeat this a bit later, but it constantly takes us back to almost the 42 legislation, section 42 in the first legislation, where they considered various factors in assessment, i.e. The economically active people in a particular category, but also the labor turnover, and we'll see how that will impact. But importantly, they want you to choose one stat, provincial or national, and stick with that. It deals with the criteria to be considered, and it's interesting that if you look at 4.4, and you must really go and read 4.4, don't have the time to deal with that in detail, but it looks at pool of suitably qualified people, labor turnover, the trends in the particular industry and business, etc. So it's important that when you do your assessment later of compliance, and we're going to come back to that those are factors that you will now take into consideration. And as I've indicated, we'll almost go back to the initial section 42 compliance when this act was introduced. It talks about affirmative action measures and what one should consider and what one shouldn't. But what is really new, for whatever reason, is that it says that it's of a temporary nature. There's no sunset clause when the act was introduced. But when you look at local and international legislation, and it implies that when you've reached your targets, you can park, quote unquote, it for a while. And it says that it will be applied in a nuanced way. That's what it says, but what we can tell you from experience is that once it's done, that inspectors will visit mostly the larger employees, and they will apply this rigorously. And we need to ensure that once it's finalized, that there's proper compliance. Again, it talks about compliance and the analysis, and you need to look at regulation, the draft regulation 4.5, to understand it, because ultimately why we're doing this, there may be penalties imposed, and now they've introduced a new test. It talks about justifiable and reasonable grounds. Justifiable wasn't previously regulated, and it may bring about a new emphasis. It's almost like you want to bring in common law in the equity test, and one will see how that will play out. But it is a new ground, strictly speaking, that was introduced, that will impact ultimately on whether there will be fines imposed or not. But it does say that in terms of compliance, again, please consider 4.5. It will look at the business economics and business circumstances. And that brings about the old play that it's also about the financial affordability when you apply affirmative action. What is interesting is that there's a new 4.7, which is new in terms of what they've set out, but not new in terms of law. And it says you may not terminate on any grounds, to put in simple terms, to replace a non-designated person with a designated person. And that's in line really with international law and the old decision of the Weingarten judgment coming from the Equal Protection Clause in the 14th Amendment of the US. And that deals with a scenario where the employer said, in my retrenchment exercise, I'm going to focus first and give priority to the, in our terms, into the non-designated groups. In other words, my males, and I'll retrench them first. And what the court said there is you must look at less intrusive means to achieve your goals. Now, if you look at 4.7, it says you cannot terminate on any ground, so it goes as far as that is concerned. So those would be the major implications, and just touching on that given our limited time frame. Thank you, Patini.
Thanks, Hugo. Just to pick up on what you mentioned earlier, that as a firm, we had made comments on behalf of clients as well as ourselves as an employer within the South African economy. Let me just rope Imran back in. Imran, from your view, what you've seen in the current draft of the regulations, where did some of our comments end up in informing at least what we've now had as a second iteration of the draft?
I think that's a good question, Patini, because I remember some of the conversation a year ago was, well, to what extent are these comments really going to be taken into account? And I think the regulation itself speaks to that. So paragraph 3.1.4 of this regulation says it, and it says that the minister in the publication of the current regulation took into account the unique sector dynamics raised by sector stakeholders in their written submissions during the consultation process. So I think that's the complete answer to the questions that were asked of us in the last year. Well, are the submissions going to have any impact? So have the submissions had an impact? Absolutely. Prof has made the point on a number of significant changes from the 23 regulations to the 24 regulations on issues relating, number one, to where do you match, the sector targets, the PEE sector targets when you read them against the employment equity sectoral targets. That was a big topic during the consultation process or the submissions. There's one example of it. There's also now a better understanding of how it is that the minister came to make these determinations as opposed to what was published last year. So a fair bit of what certainly now sits in the regulations, I believe, has come about as a consequence of the submissions of last year. To Adil's point earlier, that employers should give serious consideration to submissions. It's not a marketing ploy. It's something that's got to be considered. We're going to touch on the concept of EAPs per province, EAP national. Those are important in determining how the sectoral targets are going to be applied in particular businesses and how compliance is going to be determined. So individual employers need to make a determination of how that's going to work in their own businesses, and then provide commentary, either through their own business or particularly through a sector, so that those inputs can be taken into account during the next 90 days. So the short point of all of this is the submissions were taken into account, and we would certainly encourage sector stakeholders, particularly employers, to make positive submissions in relation to this version of the regulations.
Okay, Imran. Prof, let me circle back to you just from a comment perspective. If I could ask you to just please highlight some of the very, very critical comments that we made as a firm and which have now found their way into the current draft of the regulations.
Thank you, Patini. Well, I can tell you, if you look at 4.4 by way of example, all of those, I don't want to be arrogant, but are the ones that we submitted. Inherent requirements of the job to be considered in preparing the employment equity plan. The following criteria to be taken into consideration: pool of suitably qualified people, qualified skills. And I remember us using from experience the typical sort of family business, 50 employees, low on labor turnover, in a highly skilled environment of engineering, relatively few qualified, suitably qualified people in that scenario. The rate of turnover in that particular businesses would generally be slow. Those are the typical submissions we've made. We've set about look at recruitment and promotional trends. And again, going back to the initial amendments, is that to what extent we must compare ourselves also with other employers in that industry and stakeholders, because that won't be considered in isolation. The whole picture will be considered, and I'm going to come back to that later, because what you're really doing is you're going to look at compliance. Other factors under 4.5, all coming from what we've seen in our papers. Insufficient recruitment opportunities. We've dealt with that. We've dealt with insufficient, and I'm reading from the draft, insufficient promotion opportunities, transfers of businesses, mergers and acquisition, impact on business and economic circumstances. I've dealt with that. Those are all submissions that we've made, and as I've said, the minister kindly considered that, and it's there for our reading. And it's now really to the employers to assist us to make more submissions that will make this more attractive and more workable, because ultimately we need to achieve proper and significant equality in our country.
Yes, certainly. And I'd like us to just explore the role that was played by Solidarity, the Solidarity settlement, and how that influenced the republished regulations. Imran, if I can just ask you to take us through some of the critical elements of that agreement that we see from the current version of the regulations.
Sure. So Prof mentioned the issue with regards to affirmative action being of a temporary nature. And now I think I'm giving away my grey hairs now. If you remember the debate in the early 90s as to how long is affirmative action going to be the law? Debate at the time was there going to be a sunset clause in relation to affirmative action? In the position was no, there would not be, because you've got to achieve affirmative action. It can't be within a period of 10 years or 30 years or whatever the time period was. So it's quite interesting that now the regulations provide that affirmative action is of a temporary nature. So that was never written into our law. And what's quite intriguing is that the regulations say that it's in line with its temporary nature is in line with the Constitution. But the Constitution itself doesn't say that. And where do we first trace this? You actually trace it to the Solidarity Settlement Agreement with government that was made in order of court last year. So that is quite an important element that has found its way into the regulation through that settlement agreement. And so I would think that's one very important aspect out of that settlement agreement that's found its way into the regulations.
Yes,
May I just mention this, Peteni? It's interesting.
Certainly.
Why have they been so cautious about this solidarity comments and the application they brought? But what is interesting, if you look at paragraph 48 of their submissions, it said that the South African it relied on the South African Human Rights Commission's Equality Report of 2017-2018 that says that the EEA is not constitutionally compliant, or at least that was their interpretation of it. And it's interesting that whether it's that threat or otherwise that moved them into entering into that so-called agreement with Solidarity. And we've seen some of those clauses, but in our minds, there was nothing really new or impacted on what was already common cause. But that's a different debate at a different forum for another time.
Thank you for that. Now on to compliance. I mean, we have clients who operate in various sectors of the economy. What should designated employers be expected? Well, what should they expect, or at least envisage, will be required from them from a compliance perspective? Imran, if I can just start with you.
I was hoping you were not going to start with me, Peteni, because
I'm giving Prof a break so that he can rest his
No, I was going to say to you, because this concept or this portion of the regulation, which is actually the meat of it, is, I'm going to say this, it's almost an exercise in astrophysics for me. So here's the deal. Now that you've come to me first on it, all right, I'm going to give it my best shot. I'm going to try and explain it the way I read it, and then after that, I'm going to say it's Friday was our weekend on it. Right. So here we go. we've already started out. We know that there's the annual numerical goals. That's the first aspect. The numerical goals are obviously, as it suggests, numerical goals on an annual basis that must achieve a 5-year target. So that's where an employer needs to get to on a 5-year basis. Now, the obvious complications then arise as to what happens in relation to businesses that have a national footprint and those that just have a what the regulations calls regional or provincial. Now, I'm not too clear what's the difference between regional and provincial, because are we speaking particular towns? Are we speaking municipalities? What are we talking about? But that needs to be teased out in a further version of this regulation. But to keep it somewhat simple for the purposes of this conversation, I guess you can just simply say there's provincial or national EAPs. We know that. So that should be applied dependent on whether the employer operates his business nationally or provincially. Okay. Now, the national EAP would apply to a national business. So a national business would apply the national EAP. A provincial EAP would then apply to a business which operates in a particular province. Okay, I'm going to say that again. The provincial EAP would apply to a business that operates in a particular province. And the but then comes in further down on the regulations, where it says if that business operates in more than one province, then the employer may choose the EAP of the province with the majority of employees. Okay, so that's going to get a bit technical. And then an employer that operates in more than one sector should choose the economic sector with the majority of employees. Now, there's an interesting element here, which kind of it accords with our general principles of labor law of majoritarianism, right? And this concept of majority of employees also applies in relation to the EAPs in the like. So the annual numerical goals will then be measured against the annual goals that are set, and then they'll be determined with reference to the 5-year target that Prof made reference to a little earlier. So it's quite a mouthful, but that's, once you tease it out, the best explanation that I can give in relation to it. And I guess one of the big takeaway points from this presentation today has got to be that persons within businesses that are going to be responsible for giving effect to these regulations and the new EAP, employment equity plans and reports, should just take some time. And when I say take some time, I would say some quiet time. Read the regulation, look at the sector targets, look at your existing employment equity plan and say, should this become law? Well, in fact, when this becomes law, presumably during the course of 2024, how do I apply this over the next 5 years? Now, then try and make sense of that within your own business. And if as a practitioner within your own business, you say this makes perfect sense, fantastic. If you say this actually creates a number of difficulties practically within the business, then please make comments. Because as Ariel said rightly earlier during his introduction, once this becomes law, it's going to become law, and you don't want to have to go through the Department of Employment to have compliance problems with the DEL in relation to interpretation, and we see so much of that, or have to go to court on an interpretation of the regs. You don't want to do that. Make the submissions now to say, on our application of these regulations within a particular business, it works or it doesn't work. And I think that's going to be extremely useful for businesses across the country.
I couldn't agree more with you. I think the quiet time should actually be taken now whilst it's open for comment, because you know the type of business you run, you know what are the pains of your business. It's important to at least see your business being represented in what will ultimately be the final version of the regulations. Prof, if I can just ask you to come in there, your view on the compliance obligations. Yeah. I know we're still in draft version, but I mean, we can almost accept that we are getting there to some finality very soon.
Yeah, thank you, Pateni. It's such a difficult one. But what we do know when we advise, we always advise with regard to potential remedies. And what you essentially will start doing is you start preparing your paper trail in case there's enforcement of compliance, because we know that there are huge penalties to be imposed, and we know that if you follow the court's judgments, it's not of a punitive nature. So what you will do is you'll consider those factors already listed, and we've dealt with that before in terms of the judgments. You look at the 42 compliance, and you look at the other points raised in this regulation, draft regulation. But I think that's important that you start building that paper trail, i.e., and from day one, you know, what about vacancies? What about money spent? What done to attract people? I'm just giving a few. What proper assessment of your labor turnover? What is the financial position of the company? How much have we spent? Have we appointed mentors where we could? What about other compliance of this similar legislation? You shouldn't have employment equity issues or unequal treatment cases against you. What are the pool of suitably qualified people? How do we advertise? I've made this point several times. We can't have a recruitment policy of giving preference to internal people before we go external, because if you internally mostly white male, then it constitutes a barrier. So all of that are opportunities that may arise or may not arise, but you need to keep meticulous record about cash spent, succession planning, and all of that. And once you have that picture of proper audit trail, test that against the criteria, test that against 42, test that against court judgment, and ensure that you will, at least if you're going to be taken to court, that there's a justifiable reason or reasonable reason for ground for not being compliant. And it's important that employers start with that exercise, irrespective of the status of this, because one way or another, the court will always have to consider that in any event. And if it doesn't, then there's something wrong with the system. But it will remain a great challenge for employers, and I'm sure we'll stand up to it. We'll make our comments, and we will, as always, endeavor to comply with the spirit of the law.
Prof, can I just make another comment? It's not particularly, it's not related to compliance. It's related to the EAP, and I quite often say this just socially to people. There's an absolute importance in participating in the national census. When the national census occurs, every 5 years or whatever the time period is, it is fundamentally important as an individual, as at the level of a family, that you participate in the national census. These numbers are not pulled out of the air. So government does not pull the numbers out of the air when the sectoral targets are being determined. And EAP constitutes the economically active population having regard to the national census. So these numbers come out from somewhere. So I mean, we don't have to get into debates about crime in the country and, you know, all of those sort of issues that people have personally in interacting with census. But we need to be alive to the importance of participation, because ultimately this has an impact on how it is that employers at the end of the day are to implement employment equity within particular businesses. So if we don't participate in the census, that has an impact ultimately on this. It's almost, it may be like saying, well, I'm not going to vote. So then, you know, democracy doesn't work. So I'll use the opportunity now to say, let's also make sure that we go out and vote in 2024. And also, so we've got to participate in the process. Again, to the initial points that we made, and I think that's the big takeaway from us, is please look at the regulations. We're not here to provide full-on interpretations of the regulations, because what we interpreted last year is fundamentally different to what we see in 2024 in these regulations. The onus is on employers and on practitioners who are implementing this to have regard to it, consider, make submissions, and participate in the process. And that public participation process has yielded a result, and a very positive result, I think, in relation to the 24 regulations, and what will hopefully be an even better draft within the next 90 days, or after the expiry of the next 90 days.
Thank you for that, Imran. In fact, Item 1 speaks about the minister identifying national economic sectors having regard to any relevant code contained in the Standard Industrial Classification of all economic activities published by Statistics South Africa. It makes your point crystal clear. It's important that we participate because data is certainly drawn from somewhere. Let me
I just ask Imran and Hugo, sorry, Piteni, just to interrupt. They have not seemed to resolve this issue, which is how is it possible to publish regulations pursuant to an act that has not yet been effected in law? And what challenges will you face as a result of that? Because that hasn't come through in the explanatory memorandums. And then while I have the floor, we're going to just try and answer some questions on the chat, and just to Piteni and Imran, just if you could look at the chat just so that we can see that. A copy of this presentation will be sent to all our clients. This webinar will be sent to all our clients and placed on social media as well. But I think for me, that's the fundamental thing. And I think we raised it in our initial comments, and it needs to be raised again. That how are you consulting on regulations pursuant to a piece of legislation that's not yet law? And then are these consultations actually valid? That's going to be a debate that's going to have to be resolved at some point. I'll leave it to each of you. Thank you.
Imran, shall I go? So my sense is, and Adler is 100% correct, if it's going to be challenged, and if these regulations, ultimate regulations to be passed will be challenged, it will be saying that those consultations were premature and it could not have been done unless the act was properly passed, and that has not happened. And that's a point we raised on behalf of most people we made presentations for, and it's clear that that will be the challenge, and it will impact ultimately on people who want to take these type of points when you challenge this legislation. And when you go to court and there's a potential of a challenge in terms of a high penalty to be imposed, that will be exactly what employers will do. They'll certainly use this opportunity.
I think that's right, Prof. The point in relation to the consultation in the absence of the legislative provision for it is a I don't want to say it's a technical legal debate, but it's an important legal issue. It just does. However, the legal debate aside, the question is what happens if you don't make the submissions? And I guess a lot of employers were in that precarious position in the process. Do you then challenge the regulations post the act coming into effect? Would the regulations now be in the law, or do you participate in the process, make submissions, and you kind of keep your powder dry on the rest of the legal issues? Whether there's going to be a challenge to the regulations down the line, time will tell. But certainly from our position, it has been that the submissions of 2023 have resulted in a further draft of the regulations, one that reads much easier, and a continued participation in that process should yield a further draft of the regulations, one would hope, up any further pieces that are uncertain or where there are gaps. And on our calculations, I think we've got up until the 2nd of May to make those submissions, which gives, for once in the world of employment, lots of time. But as we know, May is around the corner.
Yes, thank you. An interesting question has been posed. Does it mean that once the regulations have become effective, the current EE plans will fall off? Prof, I'll kick this into your court.
That's been very unkind of you. Thank you, Piteni. Anyway, my sense is, and we're just talking about the top levels of management that's targeted, because the lower levels you'll continue to do, but it's almost as if the minister says, you've been too slow on your progress, here's your new targets, and you'll be tested against those targets that will almost replace your top echelon's targets. And that is what you'll have to strive for, and that is what you will have to consider in terms of non-compliance, why you've not done that. So that will be the potential approach to be taken. But again, you will recall that we've made in the previous comments, we've listed that as an issue and say, be clear what you want us to do. And undoubtedly, if there's a further regulation or whatever, they'll tell us. But at the moment, it appears that would be your new targets. The minister is entitled in terms of 15 capital A to set new targets, and he will do so once he's exhausted all the procedures. And you must then, as an employer, do that.
Yeah.
Thank you.
So, Pateni, if I can come in on that point, Prof, that's certainly it's an excellent question, and one that's been raised by a number of employers. Like, what happens when these regulations come into effect? Does it mean our existing plans fall by the wayside? What do we actually do? Now, these regulations are silent on it, and you making reference to transitional provisions, but I'm not sure why this regulation actually doesn't have its own transitional provision to say there's a transitional period of a year or 2 years to move from existing plans to the sectoral targets over a 5-year period, or have regard to the existing plan and then kind of melt it in some form or manner. But it's an issue that is troubling to a number of employers, and is an area, again, in relation to comments that should be made to the portfolio committee on this, as to what is the transitional provisions going to be, and how is it that employers are meant to plan into 24-25 going forward on the new plans.
I agree 100% with Imran, and it's interesting when you look at transitional clauses. When they introduced employment equal pay in the UK in 1970, I think they allowed 5 years for people to move towards compliance. And so what will happen if this applies immediately without transitional clause? It will say from end of year 1, there are certain targets that you must now move and try and achieve within the next 5 years. And we certainly need clarity, and Imran is 100% correct about that.
Thank you. Another question that has been posed is whether your 5-year goals as an employer need to reflect the sector targets, or is there avenue for influence by various factors?
I think the long and the short of that is, if you, many employers will not meet those targets if you look at where they currently stand, and hence the reason for this new regulation. At the end of the 5-year plan, if you've not reached it, there will be an assessment of compliance, and then you will have all your ducks in a row in terms of what you've done in terms of your audit trail, and you will then deal with the justification for non-compliance.
Yes, thank you. And we are fast leading up to the end of our discussion. To close us off, Prof, I'll just jump on it with you, start with you.
Yeah.
Overall, what should employers be contemplating, and what should they actually be doing in the 90 days that have been allowed for comment? And even beyond the 90 days, excuse me.
I think that they've moved a long way in setting these new regulations. I think we're much closer to the final result, and we need to be aware of that, and we need to make those comments. It would also be interesting to see, and what we don't know yet, we're struggling to almost interpret some of it, how the inspectors will interpret it, because we've seen in the past when they visit our clients that they have a quite strict approach without considering the relevant assessment regulations and guidance. And you know, what will they do, for instance, in year 1 if you've set a target? My experience is that they will use this opportunity to make it difficult for the employer, in sometimes in a good sense, sometimes in a not, but we need to be very much aware of that. Bottom line is we must make an input so that we can influence whilst we can.
Thank you, Prof. Imran, perhaps you could close us off. You discussed this earlier, the national and provincial targets, and an employer's discretion essentially to choose which targets to apply. The question that's been posed is, to what extent does an employer have the discretion to choose between the two?
It's not an open discretion in the sense that you get to choose one or the other. If you're a national business, you've got to use the national EAP. So there's no discretion. The discretion applies in relation to where you've got these provincial businesses, as it were, and so that's the one aspect. Then so the regulation is not entirely clear in relation to this, how this, I'm going to use the word discretion in inverted commas, is to be applied, and there's couple of gaps in there, and that's why the initial point, or the point a little earlier, was read current regulation with reference to your own business, then apply what you read on your interpretation of it to the sectoral target and how it is that you're meant to achieve it over a period of time. If you're able to achieve it, well, then fantastic, this regulation makes lots of sense. If not, then there's an issue. There's, for instance, an interesting question in the chat about the provincial targets. Right now, we've picked this up during the course of our prep, that there aren't specifics in relation to the provincial EAPs in the regulation. Now, it begs the big question as to, well, now how do you apply a provincial target when there's no reference to it? So what is the employer then supposed to be doing? Because the reading currently on the regulation seems to be a suggestion of the national targets. Yeah. So there's lots of question marks on the current regulations. The point of this discussion is an early opportunity at this point between now and May for employers and practitioners within a varied number of employers in different sectors to apply this and see how it actually is meant to work out, and then make submissions and provide and ask the necessary questions, so that hopefully the next version of the regulations are much easier to understand and, more importantly, to implement.
Yeah, and I think the point that's so important that Imran is making is that there's whole nuance between provincial and national, but once you have a choice of doing provincial, and it says that you must then stick to those provincial targets. So it's not the one and the other. Whilst the Act is quite clear, it's an and, it's not and or. When the Act changed and subsequent to that constitutional judgment, is that it used the word, the Act may, in addition to the factors stated in 15, consider the following. Now it says may, previously it said shall. And that interaction, as Imran has said, will have to play out, and we need clarity on that. But that's why we need to make submissions so that we get that guidance to defend ourselves if necessary as employers.
Can I just raise one thing that you consider? So we in approximately over 20 years into democracy, and when making comments and what we're seeing happening through the court processes, is that there's a definition for designated groups. And what's becoming more apparent by various individuals, because there's opportunities for various categories of people within the designated groups and even outside, is how do you define what is Black? And I think that's going to be the challenge that we're all going to experience. There's some case authority on this, but start considering it. I know a number of clients have had employees who have identified themselves as Black, or have identified themselves as male or female. And I think that this year is an ideal opportunity to raise those challenges in your commentary, so that we're not only relying on the courts to define our identity and our race as such. Thank you, Peteni.
Thank you, Adil. And may I add to that? Interestingly, there are people who actually prefer not to say what they identify as, and how will that be dealt with? So thank you. That gives us food for thought. And the quiet time that Imran spoke about, I think these are some of the issues that we need to grapple with, that we need to ensure make their way, at least be considered by the time that the open window for comments closes. Prof, you seem to want to share something as a parting shot before we close off on the session.
Maybe I can just repeat what I've said several times in the past, and it's not enough to change legislation. We need to change the heart of our people. And I'm borrowing from somebody else. And that remains part of our ethos as good South Africans.
Thanks, Prof. And thank you, Imran. This was certainly an interesting discussion. I believe that our clients and the various stakeholders who've joined us found it very useful and will be responding positively to the call to take action, to make comments. We've also noted the questions that have been posed in the chat. Adil mentioned in the very beginning that we will be publishing a revised leadership thought piece. We will take into account the various comments and questions. Thank you for setting time apart on your Friday morning, and have a good weekend. Thank you.